morning, everyone. Defendants in the courtroom, and we can get started. As of last night, when we recessed, we had 45 prospective jurors. There's a little, I think, cleanup to do in that regard, so I'd like to accomplish that first. Then we have some motions, and then need to just take up any matters that need to be addressed before we start jury selection and then opening statements on October the 3rd. And we'll start at 9 a.m. And then some logistics about the courtroom we'll be using and the space we'll have. So I'd like to first start with what I think are the finishing aspects to the jury voir dire and the pool that we have. Now, we have 45 prospective jurors. I think everyone agrees with that. To me, the next question is what to do about the entire, 36, 72 of them. My inclination is that Mr. Sharon and Mr. Perdue need to call all of them, tell the 45 to come back and remind them and tell them to write it down October 3rd at 9 a.m. to come back to the jury assembly room and to discharge the remaining jurors. There's no reason for us to pay them the $25 it costs for them to come up here when they're not going to be part of the pool, or to inconvenience them. Now, does the state have any objection to the court's approach?
No, Your Honor.
Or any other idea?
No other comment.
So that's acceptable to the state?
Yes.
For the defense, Mr.
Yes,
Kilgore,
ma'am.
That's acceptable to you?
Yes, ma'am.
All right. Now, does the state have any other issues, thoughts, et cetera, about the jury selection process?
Not necessarily about the process, Judge.
Well, anything about the topic?
Yes, Judge. We did have an issue. We brought it briefly to Your Honor's attention in the defense regarding one of the jurors. We have provided printouts of some of those matters to the defense now as well. We have an extra copy for the record, too, at the appropriate time. But I think they were reviewing, I think I termed it, as we looked at it, it was very clearly it could be Brady material as far as what we were told by this juror and then what actually the juror had conducted online back as opposed to what she had testified to. Further, we found out that there had been, we had been led to believe that an account had been deactivated. We've been told she's no longer on that account. When in fact we looked at it, she actually was still active. And then the next day, actually deactivated it. And now, as of recently, I believe it's either yesterday or today, has now activated it again.
Which juror is this?
This is juror number 20 from the first panel, Judge.
And you've documented everything you just said?
We have, and if necessary, we have an apprentice that works here who has actually conducted that, could testify. We needed to put her on the record as to doing that. But I have documented with screenshots of all of the postings before she deactivated her account. We were able to take screenshots of that before she deactivated and then reactivated it.
Well, what is your motion with regard to juror 20?
Your Honor, my motion would be, I would assume the defense is going to join in this because of what she said, is to strike this juror basically for lack of candor to the court about what she had done with this account, whether it was active or not. Also, there are several comments about her opinion on sentencing and the level of guilt and his intent and things of that nature, and about how long he should spend in prison and things like that, which is contrary to what she testified here in court. I believe she should be struck, A, for an even deeper involvement with the case, showing a bias against the defendant that was not disclosed while she was here, and also a lack of candor to the court as far as how, I guess, in depth she was on this, and how she may have been violating the court's order by still being a part of this Facebook group when she told us she was not anymore.
Thank you. Is the defense ready to respond, or?
I have not finished looking through the materials that I've been provided this morning, Judge.
I can wait.
But we're going to request that she be returned, that she come back and we have a chance to question her, because I don't know what it is that I'm looking at, and I don't have all of the information that the state has. So
I don't see.
I think it's easy enough just to bring her back.
I don't see any problem with that, but I think that we probably need to do that today rather than wait.
It's fine.
Mr. Sharon, can you go call and tell her to come up here at 1:30?
At 1:30, yes.
Yeah. I mean, if you can get her here sooner, tell her to come up here ASAP.
And Judge, I know that, I know that the state is going to fully cooperate in this, and in the meantime, I will talk to the, is that intern?
I think it's technically apprentice since he's taking the bar.
Okay. And I know that they'll speak with me, and I'll find out all the information. We'll be better prepared.
I think so. Hopefully she'll be here before lunch, but if not, at 1:30.
Yes, ma'am.
Your Honor, I do have, Mr. Sharon has, I've got a copy of the questionnaire with her phone numbers and stuff on it.
I'm sure
Yeah, I do.
they have.
He's already, Mr. Pardew's already on the way.
All right, thank you.
They're better equipped probably than you are, but thank you for the offer.
You're welcome, Judge.
And if I could ask, the court reporter, you did not take down juror 20, did you?
No,
Okay. So you wouldn't have her original comments? Yes, ma'am. Thank you.
I have my notes, which are probably no better and probably not as good as your collective notes. Do you have a problem if they want to look at y'all's notes for this date?
No, Judge,
That-
Your Honor. On this issue, Your Honor, great. But we've collectively have notes on it too.
Well, I figured
Yes.
because you were asking the questions, but then everyone, I mean, when
Yes.
I was picking juries, I'd be sitting there writing everything down.
Yes, ma'am.
Let me see what my notes look like. I don't think my notes would be very helpful to yours. I was notating the things that I thought would amount to strikes for cause. And y'all were looking, I'm sure, for things also along using your peremptory strikes, so your notes would have more detail. But I was particularly listening for things that would support or not support motions for strike for cause. So my notes are a little sparse, shall we say. All right. Then we'll hold that for developing testimony. Now, anything else for the state regarding the jury selection process where we are right this minute?
No, Judge.
And for the defense?
No, ma'am.
Are we ready to do the motion in limine?
Judge, we have a preliminary argument on that. If we are going forward on the substance of that motion, that's going to require evidence and a witness. The
All right.
witness is out of the country. This is something that was filed the day of jury selection, so based on the type of motion it is, we do have an argument that it's not timely and it's an improper use of a motion in limine as opposed to a motion to suppress, which is what should have been filed. But that's our first level argument we can handle today. If Your Honor wanted to hear evidence later, we would attempt to try to bring in the witness before opening statements.
Well, I don't have any problem with taking it in that sequence and then deciding, you know, if it's proper and if we need to have an evidentiary hearing or not. That's what you're asking me to do.
Yes, Your Honor.
Do you have any problem with approaching it that way, Mr. Kilgore?
I assumed that we would hear it later in the trial whenever that witness was available anyway.
Oh, well, but you've got the problem, well, that means they can go into it in opening statements. If I don't hear it and decide before opening. It means it's free for all.
What we're asking for is to, has to do with an eyewitness identification.
Mhm. Did you anticipate going into that in your opening statements?
Yes, Judge.
All right, so,
Okay. Well, then I guess I would be asking that it not be mentioned in opening until we had a chance to hear the merits.
well, and I think then what we need to do is listen to their timeliness argument and decide that to begin with. And if I rule that you are not untimely, then we'll do that Monday morning after we seat the jurors and before opening statements.
Thank you, Judge.
Because you can certainly draft your opening statements alternatively.
Yes, Judge.
Go ahead, I'm ready.
Your Honor, well, actually, this is a defensive motion, so.
Oh, I'm
since-
sorry, you're right. No, but it's your...
Since it's my motion to dismiss based
Your-
on timeliness, yes, Your Honor.
Yeah, you should go.
Defendant's motion 28 is a motion limited to exclude identification testimony resulting from impermissibly suggested photographic lineup. And Your Honor, what this is there was a photograph shown. The allegations are, and this was connected up via cell phone numbers, records, and things like that. The defendant, a few weeks before the date of Cooper's death, did go to a hotel, meet up, and pay for sex acts with a prostitute. This prostitute did identify the defendant.
I'm sorry, I was making a pile for this juror 20. Go back and say that again.
Okay, Your Honor, what this involves is an identification by the prostitute that the defendant paid for sex and met up with at the hotel in Cobb County a few weeks before the Cooper's death. This was the woman was located via records, via cell phone calls, things like that. And then the officers actually met with her. When they did, she described the defendant and then was shown a photograph. She said she was 90% sure that was him in that photograph. And so in addition to her photograph, or the one photo show-up identification, there was other corroboration to show that this actually did happen and this was the person on that actual day. The motion that has been filed actually is couched as a motion in limine. It was filed September 12, 2016, the day we came down to start jury selection. Judge, this is nothing more than an end around trying to, obviously they must have noticed that this was a motion to suppress and should have been filed timely well before trial in this case, so we could hear this in the merits and we didn't have this issue of whether we can talk about it in opening or not because it is substantive. They couched it as a motion in limine to try to get around the timeliness. I would turn your attention, Judge, to Tillman versus the State, which is 184 Georgia Appeals 210. In that case, page 2, head note 3, lastly, defendant contends that the trial court erred in denying his motion to suppress the identification testimony of the victim. The record shows that the trial court denied the motion, which was also filed on January 2nd, 1987, as being not timely filed and dilatory in nature. We agree with the trial court that, pursuant to Uniform Court Rule 31.1, defendant's motion was not timely filed. In this case, it's not even the proper vehicle for addressing this type of issue and this type of appeal, this type of motion. It should be couched as a motion to suppress, which it has not. So for that reason, Judge, I would ask that it be dismissed because it is not the proper motion for addressing identification, and because this was filed at such a late date, the date of trial, and it is such a substantive motion that it is something that needed to be heard well before we got to this point. So that's the state's argument in this regard, Judge. And so we are left here now. We're 5 hours away, 6 hours away, something that we actually need a witness to testify about before trial. So this motion not be heard. Further, the evidence on it will be developed at trial as well. So there will be a record regarding the nature of the identification and things like that for appellate purposes.
This isn't a motion to suppress a piece of physical evidence. What this is, it's a motion it's to limit some testimony from a witness. The motion in limine is exactly the kind of vehicle for what it is that we're seeking to limit, Judge. He went into the facts of the motion and the show up a little bit, so I'm going to, for the record, we'll clarify for you what happened. Apparently, police identified this individual, and they set up some sort of a sting. And
I'm sorry, police identified which individual?
the witness,
All right.
okay, is someone they wanted to talk to.
Okay, that's all right. I understand that, but
And instead of, when they confronted her, they gave her an ultimatum that she could either go to jail or she could cooperate. They then showed her a single photograph, and they identified the photograph for her and told her, this is the person we think that you met with recently. She was not able to give any sort of identifying information other than skin color and fat and dumping. Couldn't identify clothing, no other identifying information whatsoever. She was read Miranda rights, and essentially she could either cooperate, make the ID that police wanted her to make, or she was going to go to jail. And so it's hardly surprising that she made some kind of identification. But I think it's important to note that even under those circumstances, she still couldn't make a positive ID. Instead, she said she was 90% sure that it was the defendant in the single show-up photograph. Not going to go into the law. At this time, the court knows what the law is, regarding impermissible show-up. But that's exactly what happened here. As far as the timeliness goes, Judge, I think this is exactly the appropriate mechanism to have this matter heard. Again, we're not talking about, we're not asking to suppress a piece of physical evidence. We're not asking to suppress something that was seized, which is the obviously the purpose for motions to suppress. We're just asking to limit the testimony of this witness, and limit the identification of this witness in court. As a matter of fact, I think if we asked for this to be heard for the first time when the witness was called, I think we could have asked for it at that time as well. So we just ask that when the witness is available, that we hear it at that time.
The only follow-up I have to that, Judge, is if that were the case, then we would have motion and limines to suppress defendant's statements and things like that. It's not for physical evidence. It's to suppress substantive evidence in the case, and I think that this is that exact type of motion.
I don't have the rules with me. What do the court rules say about timeliness of motions? You have them with you?
I'm sorry, Your Honor?
What do the court rules say about timeliness of motions?
All motions, demurrers, and special pleas, I'm looking at 31.1, shall be made and filed at or before the time set by the law, unless time therefore is extended by the judge in writing. I think that is going to be after arraignment or at arraignment, Judge. So, and usually even, there's a lot of flexibility. We don't object several times because I know there's a lot of discovery to go through in certain cases. Judges may by habit extend motions by setting motions dates and things like this. And Your Honor, it could be argued, could have implicitly extended it to August 19th by setting a motions date on that. But there has been no extension of that time since then.
Well, and Judge, if I may, I'm sorry, but you did sign an order indicating that we could file motions at later dates, and there was no deadline for that. But you gave us permission to do exactly this. I don't think this is anything that's going to delay the trial, and of course that was the court's concern, and that was really the only limitation that the court put on our ability to file motions throughout this process. So I think based on the court's order extending our time to file motions, I think we were certainly within our right to do that.
No.
And Judge, all I would say is that was in the nature of motions in limine, which this again is a substantive motion, not something talking about an evidentiary matter or something like that.
Well, the timing may be problematic, and the vehicle of the way it's brought may be problematic, but there's time before we have opening statements to get this matter addressed. And it's, I think, within my discretion to decide whether we'll do that or not. And I'm going to exercise my discretion to allow this motion to stand and to hear it before opening statements. So what I anticipate to happen August 3rd at 9 a.m. is that we pick the jury, send them back, hear this matter, then come in and have open, I'll charge them and I'll swear them and give them their preliminary charge, and then we'll have opening statements. So you'll need to have your witness here at that time.
Yes, Your Honor.
All right. Now, what else do we need to accomplish today?
Your Honor, but for the other juror, I don't think the state has anything else we need to accomplish in court today.
Oh, wait 1 minute. What else does the defense have?
I don't think anything in court. Of course, we ask that we have an opportunity to talk to the technical people and maybe see the courtroom, but I don't think anything else that that the court needs to take up, Judge.
Mr. Perdue?
I have an announcement on the jury.
Yes?
And I called juror number 20 of the original panel of 36, which I believe is who we're talking about. She can be here at 11 o'clock.
Perfect. All right. Then,
And
got just a little, yes, sir.
I told her I would meet her in the jury room, and then we'll do what Your Honor directs from there.
Well, I anticipate we'll bring her in, sit her down, and take evidence, right?
Yes, ma'am.
Yes, ma'am.
Right. Then let's be in recess till 11. Let's go and check out and see what's going on with Judge Kelly and if his courtroom's available. Probably there's some packing and things that we all need to do to move across the way. So let's be in recess until 11 o'clock.